Welcome back to Courtroom Authority, where today's case takes us to Detroit. The city is cracking down on loud music coming from cars, and the defendant, Antonio Owens, is accused of violating a motor vehicle noise ordinance. The law here is surprisingly strict. It bans sound production inside or outside a car that can be heard more than 10 feet away. Think about that. 10 feet. That's barely 2 car lengths. So the big question is, did Mr. Owens really break the law? Or is this over-policing of everyday life? Keep watching, because as this unfolds, we'll see conflicting testimony, questions about speaker systems, and even challenges to whether the officer could really pinpoint the sound. Trust me, this one gets heated.
City of Detroit versus Antonio Owens, case number SP 169-54161. Appearance for the record, please.
Good morning, Your Honor. Alexa Schneider for the people, P80322. I have the issuing officer, Corporal Croxton, present as well.
Elwood S. Berry, Jr., on behalf of the defendant. Mr. Owens is ready.
Okay, it's your burden, Ms. Schneider.
Your Honor, as a very brief opening, I would like to call Your Honor's attention to the City of Detroit Code 16123. It's specific prohibitions of motor vehicle noise. The relevant section is number 3, which prohibits the production or reproduction of sound within or around a motor vehicle, including the use of internal or external speakers while a motor vehicle is in motion or at rest. And that's all for opening, Your Honor.
Repeat that statute again.
It's the City of Detroit Ordinance 16123.
And what does that statute read?
Specific prohibitions of motor vehicle noise. And the relevant section number 3, that prohibits the production or reproduction of sound within or around a motor vehicle, including the use of internal or external speakers while a motor vehicle is in motion or at rest.
Go ahead, Mr. Berry.
There is no distance to speak of, apparently, with this statute, this ordinance, whatever it is.
Did you catch that? Even the judge sounds baffled by how broad this law is. If taken literally, it could mean no music in your car at all, ever. That's wild. Imagine driving down the street and technically being in violation just for having your radio on. This raises a huge legal issue. When laws are written too broadly, they can lead to unfair or inconsistent enforcement. And here's the kicker. The defense could argue this is unconstitutional for being overly vague. What do you think, viewers? Should cities have the power to regulate car stereos this strictly, or is that government overreach?
What you read to me is it's essentially that you can't even have any music in the car at all.
Yeah, that's what it sounds like.
Go ahead. Any opening statement, Mr. Berry?
No, Your Honor.
All right, you mentioned specific prohibitions of motor vehicle noise, and it is a noise violation to produce or reproduce motor vehicle noise by the following means: the use of a horn or warning device within a motor vehicle for purposes other than to warn other drivers of an emergency, any use of a siren, whistle, or bell in a motor vehicle unless otherwise permitted in this code, or production or reproduction of sound within around a motor vehicle, including the use of internal or external speakers while the motor vehicle is at rest.
Yes, and then motor vehicle noise is further defined if you go up in Muni Code to 1611. That defines motor vehicle noise as any sounds emitted from a motor vehicle, either by its physical or electrical components, or by noise-emitting instruments or devices within it that are plainly audible at a distance greater than 10 feet from the motor vehicle.
That's what my understanding of the So a person who violates provision of this article is guilty of a misdemeanor for each violation, and the discretion of the court may be fined up to $500 and sentenced to a maximum of 90 days of jail or both for each violation, except for the violation of 16.123, 1-1-23 of the code. A first violation for a code section 16-1-23 of this code shall be punished by a fine of not less than $100. A second conviction for the violation of this code shall be punishable by a fine of not less than $200. A third subsequent conviction shall be punishable by not less than $300 in the court's discretion of the court to 90 days. Okay, so there's no opening statements by the defendant. You want to call your first witness?
Yes, please, Your Honor. I think Attorney Harris. Does she have a different?
Ms. Schneider, can I see you in a breakout room for a second? I apologize. And I apologize for interrupting the proceedings.
Let's go back on the record with Mr. Antonio Owens. All right, now is your witness, Counselor?
Thank you, Your Honor. Your Honor, at this time, the people call our witness Corporal Eric Croxton.
All right. All right, Corporal Croxton, good morning. Can you state your name for the record, please?
Yes, Judge. Corporal Eric Croxton, Detroit Police Officer, Badge 665, Traffic Enforcement.
And can you raise your right hand, please? Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do, Judge.
All right, you put your hand down. Right. It's your witness, Mrs. Knight.
Thank you, Your Honor. Corporal Croxton, how are you employed?
Detroit Police Officer.
What are your duties as a Detroit police officer?
I'm currently assigned to traffic enforcement, primarily basic traffic and any other outstanding issues that we come across as being a police officer.
As part of those duties, do you ever drive a scout car?
I do. I drive a traffic car, unmarked, a semi-marked blue traffic SUV with traffic enforcement along the side, interior deck, and forward lights.
As part of your duties, do you patrol the city looking for noise ordinance violations?
I do in part, yes.
Okay, were you working in traffic enforcement on or about March 14th, 2025?
Yes, I was.
Okay, on that date, do you recall issuing a ticket for a noise violation coming from a vehicle?
I do.
Okay, do you recall when that interaction happened?
The date was March 14, 2025 at approximately 6:58 p.m.
How did that interaction begin?
I was southbound Rivard approaching Larned when I heard extremely loud, heavy bass, hip hop or rap music. Then I noticed an old school.
Now here's where things get tense. Officer Croxton swears he heard loud, booming bass from over 100 feet away. That's 10 times the legal threshold. He says the noise was so distinctive it stood out among other cars and led him directly to Owens's 1988 Chevy. But hold on, the defense is already hinting at a different story. With so many vehicles in the area, how certain can an officer really be about which one the music was coming from? Remember, in criminal cases, the standard isn't maybe or probably. It's proof beyond a reasonable doubt. Viewers, do you buy the officer's certainty here, or do you sense room for doubt?
Early model 1988 Chevy blue. That vehicle made a left-hand turn from Larned onto southbound Rivard.
To be clear, were you driving when you first heard that noise?
I was driving in that the prior stated traffic car in full uniform.
Okay, in the area where you're driving, is that within the city of Detroit?
It is. It
Okay.
is.
Approximately how far away were you from the vehicle making the noise when the noise first caught your attention?
That's a complicated statement. I noticed the noise first, and I was trying to locate where the noise was coming from. When I made that determination, I was approximately 100 feet away from that 1988 Chevy blue plated Lincoln 8 Lincoln 8 M0E is in Edward.
And to be clear, you were more than 10 feet away from the vehicle when you could hear that noise. 100 is more than 10.
Absolutely, yes.
Okay. Did you eventually approach that 1988 vehicle that was making that noise?
I did that, and if I can go further, that vehicle made a left-hand turn on East Rivard, and that's when I made the stop. I approached the vehicle and spoke to Mr. Antonio Lewis Owens, who was the driver.
Okay. The driver of that vehicle, do you see them here in Zoom court today?
I do, or I did earlier. I
Can you
think
please, I don't know, Your Honor, can we pin all of the video so that Corporal Croxton is able to see?
I think he needs to pin, he needs to tap his. I pinned Mr. Owens. And Mr. Corporal Croxton is pinned as well.
Corporal Croxton, are you able to view the 1, 2, 3, approximately 12 videos that are showing in the Zoom court at this time?
yes,
Okay, and in one of those 12, do you see that the person that you saw in that vehicle on that date?
yes.
Okay, can you please describe to us anything about that person on Zoom?
Look like close crop, Covalis type hairstyle, with a beard mustache. That
Your Honor,
appears to be. Go ahead.
Your Honor, may the record reflect identification of the defendant?
I'll let the record reflect, I mean, what type of clothing does he have? No one else in the room has it except for me.
Judge, was that for me?
Yeah, I got more of a Covalis than I think what you're saying.
There you go. There you go. Absolutely. So, black hair, look like a dark colored shirt. Does that help?
I'll let the record reflect that.
Thank you, Your Honor. When you approached the vehicle, did you have any conversation with the driver?
I did. I informed Mr. Owens about the context and why I stopped him. I did observe aftermarket internal speakers prior to actually speaking with Mr. Owens inside the vehicle, and that's where I heard the music coming from, or it appeared that that's where the music was coming from.
Okay, and just to be clear, when you initiated that traffic stop, could you still hear the music?
I could, yes.
Okay, and at any time before you or during that traffic stop, were you more than 10 feet from the vehicle?
Yes.
And at that point, to be clear, you could still hear the music.
I could hear typically 15, 20 feet is a good distance for a traffic stop for safety, maybe more. So yeah, at the time of the stop, I was beyond 10 feet of the vehicle and still heard the music.
Did the music ever stop?
The music did stop as I approached. Yes, it did.
To your understanding, did Mr. Owens stop the music when you approached?
That's my assumption, but I don't know for sure.
Perfect, thank you. Did you ask Mr. Owens any questions about the noise or the music, anything like that?
Not really, counselor. I made it brief. I informed him why I stopped him. I asked him for driver's license, insurance registration. He gave me those. I issued the ticket and concluded to stop. If you don't mind, the only other thing of note is he was having an issue starting his car afterwards.
And did you use the license provided to confirm his identity?
I did, yes.
Did anything else about this stop stick out to you other than the loud noise and him having trouble with his vehicle?
The only thing that stuck out was the trouble with the vehicle and the loud noise. That's it. Nothing extraordinary.
All right, thank you. Nothing further, Your Honor.
All right, Mr. Berry.
Corporal, you indicated that you observed aftermarket speakers in this old car?
Yes, I did.
And how did you know that they were aftermarket? Can you tell us where they were?
Okay, so from the back, I noticed what looked like 6x9s. I couldn't tell you what model or brand they were. One of the things I would like to do in a situation where there's loud music is identify whether there's aftermarket equipment or not. And in this case, I did see what appeared to be, seeing that this is a 1988 old school Chevy, it appeared to be aftermarket 6x9s in the back.
Were there any other passengers in the vehicle?
There were, as a matter of fact, there might have been another vehicle that pulled up during the stop, but nothing that I took is of note.
Well, the other passengers, did you notice them? Were they adults?
They were adults. I did notice, thinking back here from the stop, an older gentleman in the front passenger seat, and that's all I can really recall concerning the other passengers in the vehicle.
I have nothing further, Your Honor.
Very briefly.
I have two questions. One, you said, Parson, you said it appeared that this music is coming from this vehicle. I made note of that. And I particularly made note of that after you gave the testimony that you were more than 100 feet away, and that you what did you mean by you? It appeared that this music was coming from the vehicle.
Being that I was 100 feet away, I really couldn't be 100% or have a 100% certainty where the music was coming from. So it appeared to be that vehicle, which prompted me to follow that vehicle down to Jefferson where it made that left-hand turn on East Jefferson before I stopped it. The noise continued to emit from the vehicle, which confirmed my suspicion about what appeared to be the source of the music. And here I am.
You said after you stopped the vehicle, you still heard the music coming from the vehicle?
Absolutely. After the vehicle pulled over to the right curb lane next to the bike lane, the music was still going. I ran the plate, exited the vehicle, and I don't know, I'm assuming Mr. Owens cut it off, but as I approached the vehicle, the music ceased, and I had a conversation with Mr. Owens.
Go ahead, Ms. Snyder.
Thank you, Your Honor. Very briefly, just for my own knowledge, what's a 6x9?
A 6x9 is the measurement used for the oval shaped speakers common in the I guess the music speaker production industry. It's a little bit less beefier than an 8-inch, but more than a 6x5. So it's a measurement for a particular type of speaker.
It's the oval shape of the speaker.
Yes.
It's got the woofer and things in there. All right. Anything further?
One final question, Your Honor. Corporal, just to clarify based on Judge's earlier question, are you satisfied today, and were you satisfied on that date, that the noise you heard 100 feet away and 10 feet away was coming from that vehicle, the 1988 driven by Mr. Owens?
Yes, I am satisfied.
Thank you. Nothing further, Your Honor.
All right. Mr. Berry?
Ms. Corporal Croxton, this is like 6 or so in the afternoon. Were there other vehicles on the road?
Yes. I'm sorry, Counselor. I wasn't sure you were finished. Yes, there were other vehicles. This vehicle stuck out. This vehicle was extraordinarily loud. It stuck out. I followed the vehicle and stopped it.
Nothing further, Your Honor.
All right. Any more witnesses, Ms. Snyder?
No, Your Honor. It's our only witness.
That'll conclude the people's case.
Yes, please. The people rest.
All right. As far as the defense.
Your Honor, I'd call my client, Mr. Owens.
All right, Mr. Owens, good afternoon. State your name for the record, please.
Antonio Lewis Owens.
Can you raise your right hand, please? Do you solemnly swear or affirm that you will tell the truth, whole truth, and nothing but the truth?
I do.
All right, you put your hand down. All right, go ahead. Mr. Berry.
Mr. Owens, do you recall the date and time referenced in the direct as to receiving this ticket?
Yes, I do.
And you were driving a 1988 Chevy at the time?
That's correct.
And when the officer pulled you over, were you alone in the vehicle?
No.
Who else was in the vehicle?
I had my closest friend from 18 years. I had my 2-year-old son in the back, and I had my 3-year-old nephew.
Okay, the descriptions of the children are who was in the passenger seat?
My friend, long-term friend.
His name was?
Preston Kennedy.
Let me stop you before you get too deep into this, Mr. Berry. Mr. Owens, do you know that you have a right to remain silent?
Yes, I do.
And do you know that that your silence can't be used against you?
That's correct.
And do you know that it's the people's burden to prove you guilty beyond a reasonable doubt?
That's correct.
And you don't have any obligation to say anything. You understand that?
Yes, I do.
And you know that that silence cannot be used against you. You are correct?
That's correct.
And is it your now you understand you have the right to testify in your own defense or recall witnesses. You understand that?
Yes.
And is it your decision to testify on your own behalf?
Yes.
All right. Go ahead, Mr. Berry.
So you had 2 children in the back of your car and an adult in the front passenger seat?
Here comes the turning point. Antonio Owens takes the stand and he flatly denies the officer's version. He says his 35-year-old car only has 2 factory door speakers, nothing powerful enough to blast music across the street. He even claims it's impossible for anyone to hear his music 20 feet away, let alone 100. That's a bold claim, especially since he admits he was playing music earlier in the day. The defense is trying to paint this as a case of mistaken assumption. Maybe the officer heard someone else's car and blamed Owens. But here's the challenge. Will the judge believe a police officer trained in traffic enforcement or a defendant insisting his car is basically too old and weak to break the law?
That's correct.
And was your vehicle, what was the status of your windows at 6:30 in the afternoon? And
back windows was rolled up. Front windows was rolled up. I lowered the windows once the officer approached.
Do you have aftermarket speakers in your car?
No.
And well,
I also got something to add too. He said when he approached the vehicle, he seen 6x9s. I'm standing
Your
by the
Honor,
vehicle.
I object. This isn't even in response to a question. It's a narrative.
I'm standing by the vehicle. I can actually show you it's not 6x9s in it.
Hold on, Mr. Is an objection. Well, can't the defendant give a narrative? He wants to testify on his own behalf.
And also the officer said he was able to see the six.
Wait a minute, Mr. Owens. I'll let you know when you can speak. Counselor?
I don't believe so, Your Honor. I believe that the testimony has to be in a question and answer format. And Mr. Owens is just pontificating on his own behalf. He does have a counselor.
Go ahead, Mr. Berry.
So what do you have aftermarket speakers in your vehicle?
No, they're factory speakers. This car is over 35 years old.
All right, let me put Mr. Berry and Mr. Owens in a breakout room. Let me see if you can help him develop his testimony. He wants to say something. All right, Mr. Berry. All right, let's go back on the record with Mr. Owens.
We lost Mr. Berry.
Your Honor, we need a moment. I'm going to join the breakout room with Mr. Berry and Ms. Bradfield. I'm not sure what the basis of the objection was, but we're actually assigned to assist each other today. And each person that appears that gets appointed and represented by House Counsel is represented by each and every one of us. If Ms. Schneider needs to confer with her colleagues, there will be no objection on our behalf. I'm going to confer with my colleague with regards to the case.
Your Honor, just for the record, we're in the middle of trial. Attorney Berry didn't even request a recess or to speak to his client. Your Honor gave him that opportunity, and now it's all of the attorneys going in to tell Mr. Owens what to say or to inform him or to advise Mr. Berry. Mr. Berry is a competent attorney, as are all of us. We are in the middle of trial. I ask that it continue.
Yeah, okay, and we'll get it continued, but the notable, we're back on the record with Owens, but you objected to Attorney Harris helping Mr. Berry or what you described as helping Mr. Berry, and I'm just, I mean, after listening to Ms. Harris's response to that, I am trying to get an understanding of, is it the time reference that you're talking about, or is it the fact that Ms. Harris is assisting Mr. Berry? Because I wouldn't have any objection if Ms. Schneider or your whole team came to assist if that was necessary. I mean, if you bring a slew of lawyers, I don't know what the basis of that is for.
And I would ask that we make a record, Your Honor, that it's co-counsel, that it's Attorney Berry, Attorney Harris, and Attorney Bradfield. Then we'll make it a record as opposed to going off into a breakout room in the middle of trial.
I can understand that. All right. Ms. Harris, you want to put your appearance on the record, and we'll bring Ms. Bradfield out as well.
Cherika Harris, P72832, House Counsel for Courtroom 434 for July 1st, 2025, appearing on behalf of all litigants who have not retained their own counsel.
All right. Ms. Bradfield, good morning to you. I mean, good afternoon now. Can you put your appearance on the record for Mr. Antonio?
Daphne Bradfield, on behalf of Mr. Owens.
Okay. Mr. Berry.
Yes, Your Honor.
I gave the reason for allowing Mr. Berry time to speak with Mr. Owens was, is Mr. Owens, well, he's here, is because, Mr. Owens wanted to say there was an objection to him have given a narrative. I gave Mr. Berry an opportunity to speak with his client so that they can further, so he can get a proper defense. All right. So in the meantime, Ms. Harris went into the breakout room, and Ms. Bradfield spoke with Mr. Berry as well. There was an objection because of that, because it was in the middle of trial. I think that Ms. Schneider was right. If there was no appearance put on the record before that, whether that's a violation of many of the rules, I haven't heard specific rules for me to rule on, but Ms. Harris and Ms. Bradfield have now put their appearance on the record for Ms. So that's what we'll let the record reflect. That's what's gone on so far. We're back on the record with Mr. Owens, and if there's anything else you want to make up for the record, counselors, you can right now.
Thank you, Your Honor. Mr. Owens, can you tell the court, indeed, where were you pulled over by Officer Corporal Proxton?
East Jefferson.
East Jefferson, can you be more specific than that?
I don't know the exact street. It's about like a Chevy dealership.
Okay. Okay. And so were you ever on Rivard?
No.
And let me ask you this. Officer Croxton indicated that he saw speakers in the back of to the back window.
That's correct.
Is there why? How did he? Could he? Is that possible with your vehicle?
No.
And why is that not possible?
Because my windows through the back of my car, you can't see anything. It's 0% tint.
All right. And Your Honor, we're prepared to show the vehicle. And you've already testified that you did not indeed have any aftermarket speakers.
No.
All right, I have some questions.
Well, sir, were you playing music or anything to a point, you know, that it would be loud enough to be heard as far away as Officer Croxton indicated?
No. 100 feet, impossible.
What about 20 feet?
Impossible.
And why do you say it's impossible, sir?
Because I only have 2 door speakers, and that's it.
And you also indicated there were 2 children in the back seat?
Yes, 2 and 3-year-old.
All right. I have nothing further, Your Honor.
Let me ask you this. Were you playing music, sir?
Yes.
All right, Ms. Snyder.
Thank you, Your Honor. Good afternoon, Mr. Owens.
Good afternoon.
So you told your attorney earlier that you were not driving on Rivard. Is that correct?
That's correct.
Okay. Did you strike that? Do you dispute that you were pulled over by Corporal Croxton on that date?
You saying, I'm saying, you asking me, did he not pull me over?
I can rephrase it. Do you agree that you at some point on that date did get pulled over by Corporal Croxton?
That's correct.
Okay. And when you did get pulled over by him, were you playing music in your car?
No.
No? Were you ever playing music in your car on that date?
That day, yes.
Do you know when on that date you were playing music?
I wasn't trying to keep track of what I was playing or when I was playing it, but
Okay,
I was playing the music that day.
Okay. Do you recall when you turned the music off?
No.
Okay. You said earlier to your attorney that you have 2 speakers in your car. Is that correct?
That's correct.
Okay. And where are those speakers located?
On the bottom of my floor.
The bottom of your floor. And you said earlier that your windows were partially rolled down. Is that correct?
That's correct.
Okay. You told you don't remember when you were playing the music, but you do agree you were playing it at some point on that date, correct?
That's correct.
Okay. If your windows are rolled down and you're playing music through your 2 speakers, would it be possible for someone outside of the car to hear that music?
Standing next to me?
Beg your
Possible.
pardon?
If someone was standing next to my vehicle, that's possible.
Okay. Have you ever tested that yourself?
Yes, I have.
Okay. On that date and time when Corporal Croxton said he heard your music 100 feet, 20 feet away, were you standing 20 feet behind your car?
No, I wasn't.
Okay. When Corporal Croxton pulled you over, did you come out and stand 10 feet behind your car?
No, he didn't ask me to.
Okay. You told your attorney earlier that your music couldn't be heard 20 feet away. Is that correct?
That's correct. And
Is it
remind you, can you imagine what some music would do to an infant that small?
Would you dispute that you could hear the music 10 feet away?
That's impossible.
What makes you so sure?
Because I'm telling you, it's 2 door speakers. That's it. It's just 2 door speakers. It's impossible. Like it was 1,000 cars surrounding me. It was a big event going on. I was taking my son to Belle Isle to spend time with him. That's it.
So the fact that there are other cars around, how would that make your car any quieter?
Because it's like he said, it's a car that stands out. So it probably caught his attention, and he assumed that was the vehicle that was making the noise.
Did you hear the corporal testify earlier that the music was still playing when he pulled you over?
Yes,
Do you dispute that?
I do.
Why would you have turned the music off?
I didn't turn it off.
You said earlier that you were playing music at some point in that day, but you don't recall when you turned it off. Is that correct?
Right. When he pulled me over, there was no music playing. I
What
was
makes you so
talking
sure of that?
because I was actually talking to him. So if it was some music playing, I would have to turn it off.
But again, you don't remember when you turned it off before.
It wasn't on before he put me over. I can agree to that.
Do you know, when did you notice the corporal following behind you?
When I crossed the light,
Beg your pardon?
when I was on Jefferson, and maybe as soon as he hit his lights, that's when I noticed he pulled me over.
So you wouldn't know for sure what the corporal could have heard if he'd been behind you before then, is that correct?
Yes, I'm sure.
Okay. And what kind of music earlier in the day would you have been listening to in your car?
Some R&B, some soft jazz, something like that.
Okay. And the area that you were in that you said was really busy, what was going on in that day?
It was the weekend. It's a lot of traffic in that area. Me and my son go down there to usually fish. It's concerts, it's all type of things go on. People meet up there just to meet and greet. It's a lot of things that's happened in downtown Detroit. It's the river walk, it's summer days, it's the summer, people get out and enjoy themselves.
All right, nothing further, Your Honor.
Mr. Berry, you indicated that you wanted to put some exhibits up or something.
Yes, I'd like the court to see the rear window of my client's vehicle. It
You
is,
showed that to Ms. Schneider?
no.
For the record, Your Honor, I'm sorry to interrupt. For the record, Your Honor, I would object. The trial has already started. If I had asked before trial had started to produce the video, which we could have done and downloaded, we wouldn't have been able to. That's Your Honor's practice, that you do not adjourn to allow us to do discovery on trial date. The pictures weren't shown to me before. We're already in the middle of trial. I would object. Or in the alternative, I would ask that we pause at this time, hold the order in abeyance. I'll download the video, share that with Attorney Berry and with his client and with the corporal, and we can also look at the video and the pictures.
All right, let's do that. Let's adjourn it. We'll pause the trial today. We're going to come back on Thursday. We're going to adjourn this matter until this July the 3rd, Thursday morning, and councils, you guys get together on what you're going to try to present. All right.
Thank you, Your Honor.
Your Honor, the only thing I'm going to say is I don't think Mr. Owens wants us to adjourn. So I think he's wanting to move forward without anything, but
Doesn't matter now what Mr. Owens wants to do. Now, do you want to proceed without the tinted windows or not?
Yes, Your Honor.
That's what the whole thing was about, right?
I would like to proceed.
All right, go ahead. We'll proceed. Is there any more from the defense? From the defense? Do you have any other witnesses? Is there any more questions? Any more testimony you want to bring out?
There is none, Your Honor.
All right, is that it?
That's it.
Any closing arguments?
Very
Your
brief.
Honor, please.
Thank you. Very briefly, Your Honor, I would just redirect your attention to the ordinances that we discussed before this trial started. They're very clear and it's very simple that any noise, be it a muffler, be it, beeping, be it music from the vehicle that can be heard more than 10 feet away, and 10 feet is pretty small, is a violation. Mr. Owens testified himself that the window's down, they're going to a loud place, they're going to go to Belle Isle. You know what people are like on Belle Isle, you want to play loud music. You want to have your windows down, that's okay. Nobody's saying it's not a felony. Nobody's saying you're a terrible person. It's just that the car is loud. Corporal Croxton testified credibly that he could hear the music from far away. He wasn't sure at first which vehicle was so loud. He had to get closer until he could see which one it was. He became satisfied that it was Mr. Owens's 1988 vehicle. When he became satisfied, he pulled it over. He could still hear the music when he was approaching, although Mr. Owens did turn the music off so he could hear him. Your Honor, he testified very credibly, even with Mr. Owens saying there's just two speakers, one speaker, half a speaker. That's enough to be 10 feet away. 10 feet, again, it is not that far. Corporal Croxton testified credibly. The ordinance is very clear. It is very simple. I believe we've met our burden more than, beyond a reasonable doubt. Thank you, Your Honor.
All right, Mr. Berry.
Your Honor, the testimony is that there were three people in the vehicle, in Mr. Owens' vehicle, two of which were 2 and 3 years old. Now, I can only speak to the circumstances. It does seem a bit much that you would play your internal music with 3 windows up and 1 partially down, loud enough to be heard even 10 feet away, without crashing the ears of these children. I'd also make the point that this was a Saturday, March the 14th, and there were many events going on downtown, and it's not inconceivable that Corporal Croxton got the wrong car, or a lot of cars, a lot of people playing music, so I don't find it so clear that it was clearly Mr. Owens in his vehicle playing this loud music in light of the circumstances in his car. Your Honor, that's the end of it for me.
All right. Okay. So what the court heard was Cox testified that he was downtown in the area of Larned and Brevard, and he heard music blaring from what it appeared to be coming from this 1988 Chevy old school that he testified to. He said that he watched the vehicle turn onto Larned, from Larned onto eastbound Brevard, and he wasn't for sure that this vehicle was emitting this loud music, but he went to further investigate that, and he followed the vehicle. He said he subsequently, when he was approaching the vehicle, he still heard, and he was probably at first more than 100 feet away, approximately 100 feet away from the car. Then as he got closer to the vehicle, he said that he had confirmed in his mind that it was certainly the vehicle coming from the 1988 Chevy old school vehicle. He approached the vehicle and he looked in the vehicle, and I don't know, I guess that's what was said to 6x9 was to support the case. That's what is in dispute here, whether the 6x9s, well, amongst Mr. Owens saying that his vehicle, that he wasn't playing the vehicle that loud, but he also said that he didn't have the 6x9s that Mr. Croxton had testified to. But when Mr. Owens testified, he was in the vehicle with an older friend, and he had 2 children in the back seat. He said he was pulled over on Jefferson, and at some point he was playing music. Now, where Mr. Owens said at some point he stopped the music, but he could not tell you when he stopped the music and when the music had stopped playing. He also testified that it was impossible for you to hear any music coming from his vehicle from 20 feet away. He said it was impossible for you to hear any music coming from 10 feet away. He says this saying that he only had 2 door speakers. And I noted that he said that the location of these speakers were on the floor of his vehicle. I'm thinking that he was meaning that it was down below toward the floor. I don't know if they were actually on the floor of his vehicle, but he said he only had 2 door speakers. He says that it would have been impossible for Mr. Corporal Croxton to see any 6x9s in his window because he had 0% tint in the windows. He did notice that he was being pulled over. Corporal Croxton testified that it was loud rap to heavy bass music coming from the vehicle. He testified that he was only playing R&B, soft R&B or soft jazz. So based on that, I do find that Corporal Croxton testimony was very succinct in what he said he saw and what he heard. He says that he heard the music at first. He had a suspicion that that it was coming from this 88 Chevrolet, and that when he investigated and got close to that vehicle, he confirmed at that point that he has. Mr. Owens' testimony is almost sometimes not believable in the sense that you say to the court that I was playing music, yes, but at some point I stopped playing music. You didn't say whether you stopped playing music when Corporal Croxton approached your vehicle. You didn't say that you stopped playing music at some point when you're coming up Jefferson before you knew Corporal Croxton. You just weren't. You did not. I'm not convinced of your testimony. Also, I'm not convinced of your testimony that you could not. It's impossible for someone to be here, even 2 door speakers. What I do understand about the statute, and this is something that you'd have to go to your legislator about. 10 feet away from a vehicle, you do not have to have any special kind of aftermarket radio in order for somebody to hear that. Now, that's what the statute says. It does say that if I can hear your music out of 10 feet away from you, then it's them. So there's going to be the ruling of the court that I'll find Mr. Owens guilty of the loudspeaker based on the testimony that was based on the testimony that I heard. I believe that the people have met their burden. As for the fine, I will find Mr. Let me see, 16-1-23. I think it's up to $100. I'll fine him $100, and I'll make a delayed sentence out of it. All right.
Thank you, Your Honor.
All right. So when can you pay the $100, sir?
I'll be down there before Monday.
Your Honor, I'm
So-
sorry, but I do have to object. I don't believe Your Honor has the ability to do a delayed sentence without the people. It's a separation of powers issue.
All right. Any objection to delaying the sentence?
Could I have a moment to talk to Corporal Croxton, please?
You may.
I'm going to put you, Corporal, in 2.
That's that. Appearance for the record. Let's go back on the record for this. Here we are. Let's go back on the record for Mr. Owens. Any objection to delaying the sentence?
I do, Your Honor. I thank you for the opportunity to discuss it with Corporal Croxton. I just had to inform him. It's a policy from our office. I've been informed by my supervisors. You know, once we go to trial, it's the deals are off. It's not something we do as an office. And I need to stand by that.
So there's no reason to ask Corporal Croxton, right? All right, $100 fine, sir. He said he'll pay it by Monday. I'll give you until August 1st to pay it. If you had any div that kiosk in the city of Detroit, I'm told you can upload the div that app to your phone, or you come on down to the courthouse and pay it in person. Those are the 2 best ways I can tell you to pay it. There's nothing further. Have a very good day, sir, and best of luck to you.
You too. Bye-bye.
Thank you, Your Honor.
All right. Croxton, be safe out there.
And he's already gone. So for the record.
And that's where today's session ends, adjourned until more evidence can be presented. This case perfectly shows the clash between law enforcement certainty and defendant denial. On one hand, you have an officer who says he heard unmistakable noise from 100 feet away. On the other, you have a defendant who insists his speakers couldn't possibly reach that volume, and even claims tinted windows made it impossible for the officer to see anything inside. So the question is, who do you believe? Let us know in the comments. Do you think Owens was unfairly targeted, or do you side with the officer's account? If you found this case as fascinating as we did, don't forget to hit that like button, share this video with a friend, and of course, subscribe to Courtroom Authority for more jaw-dropping courtroom breakdowns. Until next time, stay sharp, stay curious, and stay tuned.